So we just learned about what transitional services are, or what the definition of transitional services is. Now we're going to talk about what the federal and Kentucky law says about transitional services. So IDEA, or the Individuals with Disabilities Education Act, defines transitional services as a coordinated set of activities for a child with a disability that is designed to be within a result-oriented process that is focused on improving the academic and functional achievement of the child with a disability to facilitate the child's movement from school to post-school activities. So what that says is basically transitional services is to help the student after they have left high school. So after high school, the student could go to a post-secondary school, whether that be a 2 or 4 year college. They can go to a vocational education program. They can work with an integrated employment or a supported employment program. They can do a continuing or adult education, adult services, independent living. They can do something in the community. It's important for the teacher to know what the student's strengths, preferences, interests, and needs are in order to help the student achieve the goals that they're going to have to do whatever they want to do after they leave the high school. Now, let's watch this video that talks a little bit more about what IDEA, or the federal law, says about students with transitional needs.
You alluded to the multi-year plan or long-range plan when writing transition services. Describe the time frame to consider when crafting these services.
Number one, it's long range. It's more than a year. Now, the requirement is that you have to have this in the IEP for every kid beginning at 15 years of age, or at least first IEP to be in effect when the child reaches 16, which is 15 years of age, basically. So we know at a minimum, you're going to sit down and start putting this plan together for kids that are 15 years of age, at least 15 years of age, on. How far should that go? I think it goes through the entire high school experience, at least a year out, so that we're looking comprehensive long range in terms of what needs to happen to help that kid achieve their measurable post-secondary goal. Now, the other part about this, too, is as we begin to develop this coordinated set of activities in this big long-range plan, it also has a direct impact on involvement of outside agencies, which is another question I'm sure that you've got there is in terms of invitation and involvement of outside agencies. Does that mean that as we develop this comprehensive coordinated plan that we expect outside agencies to be there when the kid is 15 years of age? I don't think so necessarily. I think when we sit down and start to develop a plan and we begin to formulate the plan and what needs to happen, the involvement of outside agencies need probably to occur, but maybe in the junior year or senior year, depending on the kid, depending on the disability, depends on the level of service, depends on the adult agency and their policies and practices and guidelines. In other words, I don't necessarily see outside agencies sitting there in that first IEP meeting that we do develop here. But then I do see after that, depending on the level of service that's needed, that we need to begin to think about at what point in time do we need to bring in vocational rehabilitation, developmental disabilities, MHMR, adult service agencies, etc. Now, the idea behind that is that we need to invite, because the requirement is that we need to invite representatives of outside agencies who are likely to provide or pay for the transition services. But we do that with the consent of the parent or the student who's reached the age of majority. But now if we start this discussion early on, like at 15 years of age, then we can begin to talk about, and as we put this plan together, what kinds of services, who needs to be involved, and at what time. Then we can begin to prepare students and parents to think about, well, we need to bring vocational rehabilitation on board. We need to get them to begin to take a look at opening a case file to establish eligibility to provide services, but we're not going to do it this year, but maybe next year. So what we need to do is get your consent to invite vocational rehabilitation to the next IEP meeting.
So if a teacher is working with a freshman in high school to design transition services and has an idea for an activity and or agency to participate in the plan that could occur maybe 2 or 3 years down the line, would you suggest writing this on a student's IEP?
I'd have it in the plan, but that doesn't mean we're going to implement it this next year, but it's a part of the plan. So that we're saying, from an employment standpoint, let's say, in terms of getting a job, keeping a job, we need to involve vocational rehabilitation. And then working with vocational rehabilitation is saying that they are more than happy to get involved with the student in the junior year to begin looking at establishing eligibility and opening a case file. So we know that because we have worked with the agencies. We know what the agencies' practices are, what their policies are. And we are then putting in the plan, then in the junior year, for instance, in this particular instance that you identify there, in the plan, it is a part of the plan where we're going to involve vocational rehabilitation in the IEP meeting to have them come and help us develop what it is that needs to happen for the student to receive specific skill training in order for them to obtain and keep a job.
There were many important things that we learned in that video, and there's also some things that the federal law says that Kentucky law says differently. So first let's talk about some of the important points from the video and from the definition of transitional services. Some of the most important points that I pulled out were activities need to be coordinated with each other, so there needs to be a reason for the activity that has to do with what the child wants to do post-high school. Next point is the process needs to focus on the result. So there's no reason for the student to do something like wash dishes if what the student really wants to do is work with computers. The next point is the activities must address this child's academic and functional achievement, so it has to help the student reach their goal. If it's not helping the student reach the achievement that they need to be reaching, there's no point for the student to be doing it. And lastly, activities are intended to smooth the young person's movement into the post-school world. So it's supposed to help the student transition instead of us just throwing them out there. So now let's compare the Kentucky law to the federal law, or the Individuals with Disability in Education Act. So the first point that I want to point out is the difference between the age. In that video that we just watched, it stated that the law says that students are supposed to be involved starting at the age of 16, so really 15, because by the time that they're 16, they're supposed to be already involved in having these goals. That is the federal law, but Kentucky actually has it as the student needs to be involved in their IEP meeting or their transitional service part of their meeting by the time that they are 14 or 8th grade, whichever one comes first. So by the time the student is 16, then they already have more of an idea of how they're going to transition out of school. Another thing that the law says in both Kentucky and the federal level is that students are required to have measurable post-secondary goals. So the teacher and the student's IEP team are supposed to come up with goals to help the student reach the success that they want once they graduate high school. And part of that, they also need to have a course of study to help the student achieve that goal. So if the student's interested in photography, then the student needs to have a course of study where they're taking classes or doing things that will help them become a photographer or work with photography. So the student could be in yearbook, for example, or just different things that their study in the school is going to help them achieve the goals that they're looking for. The next thing that I want to point out is that the law says that once the student turns 18, the transfer of rights comes to the student. So once a student has reached the age of majority and are able to be on their own. Something that we don't see on our screen but I want to point out is this law also states that students are only able to be in the public school system until the age of 21. So students can be their own legal guardian or the person in charge of their IEP meetings until they're 21, from ages 18 to 21. And the students must be informed of the transfer of rights, so from their parent or guardian to the student at least a year prior to them having the rights or reaching the age of majority. So by the time of their 17-year-old IEP meeting or ARC meeting, they need to be informed of the transfer of rights. And then the last thing that the law states, that's both in the federal and in the Kentucky law, is that the students have the right to receive a free and appropriate public education in their least restrictive environment. So students, if they are able to function at a normal level, they are able to communicate well with friends, they're able to do mathematics, and they might just have some problem in reading, they seem like they'll be able to function in a regular education classroom. They don't need to be pulled out to a resource environment. Students have the right to learn for free in an appropriate education with their peers. They don't need to be restricted in any way. The purpose of special education isn't to restrict the student, but instead to accommodate their needs to help them learn at the same rate as all of their peers.